You, Zader Yanez,
Sir,
Mr. Yanez, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On November 14th, 2024, officers were dispatched to a theft at a Home Depot in Harris County, Texas. The officers made contact with the complainant. The complainant observed the defendants enter the store, they observed the defendant walk into the store, walk to a hardware department, and approach a high-dollar Milwaukee hammer drill. The defendant, Yanez, selected one drill off the shelf and proceeded walking around the hardware department. The defendant handed the drill to the co-defendant and both proceeded to the plumbing section. The defendant opened the drill box, removed the drill from the box, and helped conceal the drill into the co-defendant's purse. The defendant discarded the empty box and both proceeded towards the front of the store. Both defendants passed all points of sale without paying. The total was $199.
Okay. Mr. Yanez, I'm going to find that there's probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to go to any Home Depot whatsoever. Do you understand? If I find that you go, I will revoke your bond, put you in jail. You will not get any more PR bonds. How old are you, sir? How old are you?
25.
What do you do for a living?
Distribution clerk.
Did you graduate from high school?
Yes.
What kind of money you make?
What kind of money I'm making? 17 an hour.
We're going to reset your case to give you time to hire a lawyer. So I'm going to have you go to Victoria, sign a reset. After that, I'll have you take your seat in the jury box. We'll get your bond conditions. We'll have you sign it. You're also not to have any contact with the co-defendant in this case. Do you understand? You violate any of these conditions, you pick up a new case, I'm going to keep you with me, and it's not going to go well for you. You understand? Okay. All right, come on.
Page 1, Adams.
How many bonds have we given or reinstated for Mr. Adams here?
So 3 in total, 1 GOP, 1 reinstatement, and then
And now he gets another PR bond?
so this one was issued with this last one.
Do you have a lawyer today, Mr. Adams?
No, sir.
Your case is 1,258 days old. It is time to put this baby to bed. Take a seat for me. Vic, do you mind appointing him a lawyer, please?
Okay,
We'll do something today.
next up is page 2. Arvalo. Maryland.
Ms. Aravalo, you were charged. How old are you, ma'am?
20.
Ma'am, you're charged with prostitution. You're facing up to 6 months in jail and or a $2,000 fine. You have already taken off on us 2 times. If it happens a 3rd time, you will stay with me. You will not get any more PR bonds. Do you understand, ma'am?
Yes, sir.
Do you have a lawyer?
No, sir.
I'm going to appoint you one today and we will figure out where we go. Take a seat for me in the jury box, ma'am. Okay,
It's
it's a really old case.
yes.
I've told him it's time to put this baby to bed.
Yes.
Is there an offer in this case?
No, Your Honor.
No,
How come after 1,258 days, there is no offer?
I'm hoping we can get a gun safety class and dismiss.
It appears that was
Come on,
probably,
Mr. Adams.
the delay is probably due to the missing dash cam that's still outstanding that we do not have.
I don't care.
Yes, Judge.
Get on it now.
Yes, Judge. Well,
Why on earth would we allow you to do this class where you get to dismiss this case when it's 1,258 days and you've repeatedly taken off? It's a rhetorical question. You don't have to answer it. But I'm telling you now, I'm giving you 2 weeks to decide what to do with this case. The next time you come here, you will either accept a plea bargain agreement or I'm setting your case for trial. Do you understand? Not only that, I'm putting an ankle monitor on your ankle now so I know where you are at all times. Do you understand, Mr. Adams? And the next time you take off, I'm going to make your bond so high you're going to have teeth falling out. Do you understand?
Judge, if I may, my client, shortly after this arrest, he lost his mother. and I believe it's the mother of one of his children.
No, my sister.
He fell on hard times. He was already, not well employed. And he's been through some rough times in his life in the past few years. He recently.
All right, pause right here. This is the emotional pivot of the hearing. The defense is doing what it should do, humanizing the defendant. Loss, unemployment, kids to support, all real, all serious. But here's the legal tension. Sympathy does not erase repeated failures to appear. Judges can care about your story and still hold you strictly accountable. So, the question for you watching is, how much grace is too much grace?
Got a job working at a Chinese restaurant, and he has 3 children that he helps take care of. I'm not exactly sure when his last failure to appear was. It might have only been 1, but he hasn't been in trouble since his arrest, I think in 2021, right? So I asked the court to withhold from, giving him an ankle monitor. The state's also missing evidence here. If we can come back.
Last time we saw him was 3 years ago, Corey. So, I have sympathy in the fact that everybody has hard times, but your failure to appear on a repeated basis is a constant kick in the ding-ding to us, and I'm not going to take it. And I'm going to tell you now, I don't know why your bond is not at $10,003, because that is what it really should be. Your bond.
This right here is the judge drawing a hard legal line. An ankle monitor isn't punishment, it's leverage. The court is basically saying, I don't trust your word anymore, so I'm going to trust technology instead. This is what happens when a case drags on for over 1,100 days. At this point, the court's priority isn't sympathy, it's control and compliance.
Bond is at 1,002, and it's way off of what it normally would be. Because I'm telling you, your bond should be 10,003, because that's what they're normally set with a person who has absconded as many times as you do now. You're lucky that you're not in custody as it is now. You understand? But at 1,258 days, I don't trust you. And so the only way I know that I'm going to keep tabs on you is with an ankle monitor. And like I said, the next time you take off, and it doesn't matter what the excuse is, the bond is going to go astronomical. Do you understand, Corey? I'm sorry, but if it were maybe 500.
And this is the mic drop moment. The judge removes every excuse. No cost, no delay, no wiggle room. This is accountability stripped down to its core. Show up, follow the rules, or face serious consequences. So let me ask you, was this judge being fair? Or was this the last chance before everything collapses?
Maybe 300, I would relent on not putting a monitor. But at 4 years or however long this case is, hell no.
I think that reflects his law-abidingness, right? That he hasn't been in trouble, had any interactions with the police.
How do I know that?
Well, yes.
I don't know.
He hasn't been. He would have been in an orange jumpsuit, I guess. If
Not necessarily. I mean, we don't know how he's been out of county, out of state. Look, you're walking out of here now. You're getting 2 weeks to decide what to do. You're not going into custody now. So you're still walking out of here, but I'm putting a monitor on you. And I'm telling you something else that I should make you pay for it, where it would cost you around $400 to $500 a month, but I'm going to eat it. So there's no excuse. Do you understand, Ms. Adams? But you got to understand that in court, we hold people accountable. You may be able to live your life like this outside of the free world, but not in court. We will hold you accountable. And the next time, get ready. Take a seat. Thank you. Of course.